All right, talking with Attorney Quentin Rhodes, who's representing Josh Clark in the political discrimination case that the Human Rights Bureau has already ruled on, at least in a preliminary way, back in September of last year. So you were explaining why the hearing is being held at a local hotel rather than, say, in a courtroom.
Sure, and it's just a process with the Human Rights Bureau. They don't have courtrooms across the state, and so if you make an allegation and their investigators sustain it, then it goes to what's very similar to a court hearing. But they don't have facilities, and so consequently you have to find your own facility for that hearing to be had. Places like hotel conference rooms or large conference rooms at banks or law firms or something similar, something that approaches the size of a traditional courtroom where a formal hearing can be held. And so consequently, that's going to be held at the Grant Creek Inn here in Missoula starting Tuesday for 3 days. The procedure is for Clark and his team, which is myself and Nicole Seifert, to present our evidence for the discrimination and also our evidence for the damages that Clark sustained. And basically our argument is that they treated him so poorly by taking him from undersheriff down 5 ranks to senior deputy 1 on the night patrol, that it was both designed to humiliate him and also calculated in a way to be unsafe, or sufficiently unsafe that a person, it's not reasonable for a person to have to suffer that kind of thing after occupying these important management positions within the organization for a period of years and then suddenly being taken down to basically to begin his career again after 20 years of honorable and exemplary service. And of course the sheriff says, I've got a prerogative to put people where I want. And that's true, except you can't do it for an illegal reason. And in this particular case, the reason he did it to Clark was not because Clark lacked training, not because he lacked skill, not because he lacked experience, but because he ran against him for sheriff and lost. And so that's just in the public sector, you cannot make personnel decisions based on that reason, that political reason. That you have to take into account the merits, someone's actual record, their actual performance, and in this case, the sheriff didn't do that when he decided to put Clark on the night patrol.
Now, the fact that the Human Rights Bureau has already ruled in Mr. Clark's favor once, is that a favorable stepping stone into where you want to go next?
Sure, and it's similar to when a police detective does an investigation of a crime. There's been some sort of an allegation, the victims come forward and said, this happened to me. So the police detective will go out and investigate the evidence and see if he believes that there's probable cause that, in fact, some sort of crime was committed and that he thinks he can identify who did it. And so then he submits it to the county attorney, and the county attorney reviews that. And if she believes that, yes, there has been a crime committed, then she'll file a criminal case. And then it goes, of course, to trial. That doesn't end the matter. And so this is similar to going to trial. We've had these officials who know a lot about human rights law, and they've come and investigated the facts and interviewed the witnesses and reviewed the documentation, and they think that there has been a wrong done here, and that was their original finding. Of course, we have to prove that in a court setting, and so we're prepared to undertake that. We know what our burden is. We've got plenty of evidence to prove it, but at the same time, the county gets the opportunity to test that evidence in a courtroom setting.
All right. Now, you expect about 3 days. Now, what remedy are you seeking for Mr. Clark?
We are seeking a monetary remedy. We are not seeking reinstatement. We think that there's too much water that's gone over the dam between him and the current sheriff administration that it's too much to ask for him to be reinstated and expect to move forward on the same career path that he had prior to Sheriff McDermott taking office. And so what our allegation is, and what I think we can prove, is that there was a constructive discharge of Josh Clark by Sheriff McDermott, and upon being discharged, Josh elected to receive his retirement, which is much less than it would have been had he stayed at the sheriff's office for the duration that he intended, which would have been after his youngest child graduated from college. So that's 8 or 9 more years of service. He lost the salary from that 8 or 9 more years of service, and furthermore, his retirement is less because his years of service is less. And so the combination of those two losses, the difference between what he would have had if the sheriff hadn't treated him the way that he did and what he actually has, is the damage that we're seeking to recover. So
do you have an amount in mind?
Well, there's a range. It's between $300,000 to $25,000 and just short of $1 million, depending on how long the hearing examiner determines that Josh Clark would have continued as a deputy sheriff prior to his retirement. And so the high end of that, if Josh had retired when he was 50, the damages are somewhere in the neighborhood of $325,000, and if Josh had retired when he was 62, it approaches $1 million. And so part of it is the hearing examiner's determination of how long he would have served. And I think the evidence is going to be another 8 to 9 years, so somewhere between those two figures is probably the most likely number we think the examiner will adopt.
One more quick question then. Once this process is finished, then does the hearing examiner then make a decision and then make an award, and then can the county go back and appeal? And at what point is this going to be over?
Well, both sides can appeal just like in a traditional lawsuit. So once the hearing examiner makes a determination, if we think that she's been unfair because she found no discrimination, or if we think she's been unfair because her award was too low, then we'd have an opportunity to challenge that in court. And likewise, if the county thinks that there wasn't evidence, wasn't fair to them with respect to a determination of liability, or if she wasn't fair to them with regard to the amount of damages, then both sides have an opportunity to appeal that. And one more thing I didn't mention is that in these human rights cases, the petitioner, the complaining party, if they prevail, they're also entitled to attorney fees. And so the county would be responsible for the attorney fees, not only for its own counsel, Mr. Carey, but for us as well.